What is the one thing I told you not to do? Right. Here we have you on bond for a DWI. And the allegation is consumption of alcohol, 0.035 at 12:12 in the morning. Guess what happens now? You're going to jail.
Your Honor, I want to address what Mr. Sandoval has gone. He started AA. He is a finance major at UH. He is not, he's asking the court to give him the opportunity to make a lawful bond because of the allegations.
You're going. There are no mistakes in this life, Mr. Sandoval. There are choices. Okay. Yes. Mr. Gatterson, let's go through some things. Since a short couple years ago, PCS, evading arrest, criminal mischief, evading arrest, criminal mischief, suspended license, POM, trespass, delivery, assault, suspended license, assault, resisting arrest, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and now 27. You are 33 years old and on number 27. You now, again, stand charged with criminal mischief. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On April 15th, 2026, in Harris County, Texas, officer was dispatched to a shooting in progress. Complainant advised that he knew defendant for 10 years and that a week ago, defendant, quote, whooped complainant's ass. On that day, on April 15th, complainant was dropping his friend off when defendant grabbed a rock and threw it at his motor vehicle. Complainant thought he was getting shot at due to the loud noise shattering the glass in the back windshield. Complainant advised it would cost him about $200 to fix. Officer observed nearby surveillance video of defendant picking up a rock and throwing it at complainant's vehicle.
What time of day or night was this? And if of all the other criminal mischiefs, is this the same complaining witness as any of the other ones?
So, Your Honor, it looks like it was at around 2 p.m. Taking a look at the prior criminal mischiefs. Your Honor, the prior criminal mischiefs have different limits.
Mr. Gatterson, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs, and I'm going to test you weekly to make sure that you're not using. You will now get a curfew of 9 p.m. to 6 a.m. and you will get an ankle monitor so I know where you are at all times. Does he have an open case in another county?
I'm taking a look right now, Your Honor.
Because we wouldn't be able to get this.
I'm just pulling up the criminal history and confirming.
How do you support yourself now, Mr. Gatterson? Are you working full-time?
Yes, sir.
I want proof. I'm not going to take your word for it, but I'm, as a condition of your bond, ordering you to work full-time, and I'm ordering you not to be in possession of any weapons, not to have any contact with this complaining witness. I'm putting another ankle monitor so I know where you are at all times, and you will get a curfew of 9 p.m. to 6 a.m. And I'm telling you now, Mr. Gatterson, if you test positive for anything, I'm going to revoke your bond. You will not get any more PR bonds. And because of all the drama, you will get a serious bond. Do you understand? I'm going to protect my community at all costs. You are on now number 27.
It looks like he does have 2 open cases out of North Bend County, a terroristic threat and a criminal mischief.
Another criminal mischief.
Yes, Your Honor.
Take your seat for me in the jury box. Can you appoint Mr. Gaddison a lawyer? I don't know if I'm going to give him another, this is yet another PR bond. Just not going to happen. Mr. Adamo,
Good morning, Your Honor.
just the last name of your client, please.
Yes, sir, Coolidge.
Okay?
And we have a package of PTI and we're waiting on a decision. I know the state has, even the division chief today, get something.
Any news?
Over right now, it was above the 41.5. So that's what you guys be changing, but I sent it to Bernadette.
Oh, you just sent the packet today?
Or the packet's in, I just flagged it for Bernadette.
Got it. Do you want to wait a little bit?
Yes, well, I'd like to reset it, Judge.
Yeah, it's not going to be long. It's 206 days old. We'll do a week and I'll waive the appearance.
Thank you.
Yeah, okay. Hi, Dane. Good morning.
I'm here, Mr. Abiding, ABA.
Okay.
This is the jury docs at 8 and Street. I'm sure he had a DWI. My understanding is he's not charged with assault.
All right. Come up, sir.
Sure. Whatever.
Mr. Abiyan, you now stand charged with another case. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On April 15th in Harris County, officer dispatched a disturbance call at a store. The complainant advised that he was working at the store, noticed the defendant park his car and get out, and approached the complaining witness's sister. At that point, the complaining witness and the defendant began to argue. The defendant began arguing to fight and grabbed a glass beer bottle and threw it at the complaining witness, striking him in the mouth, causing pain.
And do we know of any alcohol or
No,
anything,
Judge,
please?
just that he threw a beer bottle.
Mr. Abiyan, I'm going to find that probable cause exists to go forward with your case as a condition of your bond. You're ordered not to have any contact with the complaining witness in this case. And now, guess what? You will now go to jail. I'm revoking your bond. Actually, I will revoke both of your bonds. I'm going to raise them up. And then there you go. And let me tell you something. Look at me. You pick up a third case. I'm going to go bananas on both of everything. Do you understand me? You pick up a third case. You violate any conditions now. Goes with you. All right, Dane. Thanks, man. 5,001 on both.
State's conditions, Judge.
5,000.
No, it's gonna be with, yeah. No. Yeah, one on both. No alcohol, no illegal drugs, testing, no weapons, no driving, no going back to the store. Is this in the middle of the night?
We can't check, Judge.
Hi, are you ready? Good morning, please.
No, Judge.
Okay, that's it.
Mr. Hillsman.
Okay.
Best man. I know this case is old, I understand,
Has he gotten it done?
he has not been his PTI, we would be asking for one more setting for him to complete.
Hillsman, is he here?
Yes, yeah.
Come up. Tell me what you do with yourself these days, Mr. Hillman.
Work.
Doing what? You work at Taco Bell. And how many hours do you work a week?
40 up, 45, so I'm not worried about 6 days.
Okay. You have had since January to get 2 classes done and a little bit of community service to get this case dismissed. And yet you have failed and you have failed and you have failed. I am now going to,
Right out of the gate, this is a bond violation, and judges take this personally. Why? Because bond conditions are basically a trust agreement. Break that trust, and the consequences escalate fast. Question for you. If someone ignores a direct court order this early, what do you think the judge is about to do?
have you come tomorrow, and then I'm going to have you come the next day, then I'm going to have you come the next day until you get this done. Do you understand? You will now think it's a second career coming to court because of the 3 months you have failed to get 2 classes done. I'll roll into tomorrow. Tomorrow's what? Friday?
Friday.
Yes,
Then we'll roll into Monday. Then we're gonna roll till Tuesday until he gets it done. I don't know how else to do it. See you tomorrow. Sorry.
If possible, Judge.
No.
No,
He's
I'm
had-
just asking.
What's that?
He has 20 hours community service and no perfect wasn't started any of it. Could we just?
I don't, it's up to him. He'll come tomorrow, right? After that, he'll have the weekend. If he really wants to do it, he can bang out a huge portion of it this weekend.
Yes.
But after 3.5 months, 3 months, I have no, it's 3.5 months, right? I have no sympathy. That's it. Every day. Okay, you ready? Just the last name of your client.
Newberry, last name?
Thanks. Okay, where are we at?
DRAS today, BTO was approved, so,
Great, all right, so we'll set you 2 weeks.
okay, thank you.
Okay, thanks. Hi, Marcos.
Hey Judge, how are you?
What's up?
No, I'm gonna talk to Sean real quick, if you don't mind.
Yeah,
Okay, can you help me?
we had something the other day
Okay.
where your client, no, ends up, you got deported, I think. We had to issue a warrant just because,
Okay.
I think it was you.
Good.
Anyways, okay, I'll think of it and then I'll,
Okay. I got 3 in your document, Judge.
yeah, who's first?
We need alphabetical.
Just last name though.
Acevedo,
That's a bit.
ACEVEDO.
Okay,
So, long story short, we just found out the parameters of a PTI.
Okay.
She's gonna pay $650 restitution and do 2 classes.
got it. How long you want?
Well, maybe 3 weeks.
Done.
Okay.
If it's not done by then though, either day for day or she got to plead. It's 213 days now. So 3 weeks, if it's not done, she either pleads or
Get it done.
trial. Okay.
We'll get that done. Next one is the Losco VELA form. Actually, alphabetical clues to TURC.
Okay.
This case is old, Judge, doing holding on for 10 days. I want to, the discovery.
Yeah, but it's because homeboy just keeps, why is it set for dismissal today?
Because they had offered class dismissed when people were given.
Did he accepted the offer?
I don't know if it's.
Did they accept the offer?
Do have that it was accepted.
Yeah, let me talk about my Judge.
Yeah, I mean, I'll give him until Monday.
That would be perfect.
If it's not done at Monday, I'm rolling him day for day.
We'll do that.
I mean, it's 251 days.
Yes, sir.
Really.
And then,
So Monday must appear. And let your client know if he ever fails to appear again. Okay, who's last?
the Losco, VELAZCO. He was denied PTI. He appealed if he was denied.
Okay.
State's offering 1 year deferred.
I'm okay with it.
Can I do 2 rats first, just to make sure?
Do you think that there would be something that would,
The reason why, it's because it was a point 294. That's my only concern. And I always like to know beforehand what's going to happen with my client.
it's a first? True first, no priors?
No, no.
Our experience is that normally they're not going to advise any kind of inpatient SAT or something like that on a first because they like to give them a chance.
Right.
If it's someone who's got a lengthy history, obvious issues at that point, we typically will see, SATF or HUA or whatnot. But on a first with no priors, and I'm okay with if you want to do that. We'll send them to go do a TRAS today, and then we'll set it for next week, early next week. But I'm telling you, my experiences is what they'll, it's probably going to be IOP, SOP is what it'll be.
Okay.
Most probably.
Okay.
And I'm okay with the deferred regardless, because it's a first, so.
Okay.
It's up to you. If you want to, we can do it today and then set it for early. Yeah, not a problem.
All right.
But next week, that's,
Sure.
yeah.
No problem. Bring it back this week. Okay, next.
Thanks, Mark. Honey,
Good morning to you.
good morning. Happy Thursday. Just the last name of your client.
The last name is going to be Lu, L-U.
Oh, this is a new case, right?
This is the new case, Jim. We're from Rain.
Do you want to hear probable cause or do you want to wait here?
I want to marry Judge only because,
You don't have to, if you want to, it's okay. Not a big
I
deal.
don't know, but I need to make that statement because the complainant in the case has a prior history resolving.
Is it two people that keep going at it?
It's love, Judge.
Love hurts, as they say, right? Right.
They don't understand, and then I try to teach them that, and that love is simply a misunderstanding between two fools, Judge.
Yeah.
That's right.
Lou, come up. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay.
On April 14th, 2026, in Harris County, Texas, complainant defendant's wife stated they had been arguing the previous day when defendant placed a shotgun on the mattress next to their 4-month-old infant.
Puts a what?
Shotgun.
A shotgun.
Yes, sir.
He puts a shotgun?
Yeah, on the mattress next to the infant. The next day, they continued to argue. Complainant was feeding their infant when defendant approached her aggressively. Defendant slapped her on the face while she was holding the infant. Complainant stated she felt pain and could not hear properly from her left ear. Officer observed red bruising on the left ear of complainant. Defendant admitted to slapping complainant in the face after she allegedly threw a baby bottle at him and because he felt disrespected by her.
Okay. Now tell me, does she have prior criminal history or does she have history against him?
Yes, Your Honor. The prior dismissed assault family member with him as the complainant.
Is that it?
That's the only criminal history.
So, Mr. Knowles
Yes, Your Honor.
and Mr. Two, Lou, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with this person whatsoever. I will now issue what's called a magistrate's order of emergency protection. This is a court order that identifies her as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order, the state can and probably will file a violation of a protective order against you. That is the capital murder of misdemeanors. Do you understand?
Yes, sir.
When I mean no contact, I mean no contact of any kind. I understand that you have a small child. You will have to use an intermediary to exchange the child. That does not give you the authority to have any contact with her. If you do, I'm telling you, I'm just going to put your butt in jail. As much as I love him, I don't care if you violate these conditions. There's only one place I have for you. Do you understand?
Yes, sir.
If she texts you, do not reply. If she calls you, hang up. If she calls you from an unknown number, hang up. You are the one that will go into custody.
Yes, sir.
Okay. You've got a great lawyer here. Listen to him. He'll take care of you. We're going to have bond conditions created for you to sign. Once you sign them, at that point, you'll be free to go. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Knowles. If he tells me he cannot get a hold of you because you're playing games, I will revoke your bond. Do not pick up any new cases. Do you understand?
Yes.
Okay, great.
Thank you, Your Honor.
Thanks, guys.
Judge, that's no.
No contact, no weapons, correct? Yeah.
Of course,
And there it is. The judge draws a hard line. No mistakes, only choices. That's courtroom language for accountability. This isn't about excuses anymore. It's about patterns. And speaking of patterns, just wait until you hear what comes next.
Morning.
Hi.
May I first?
Please. Good morning.
Two clients on the docket, Your Honor. First,
Just the last name.
Contreras.
Contreras. Okay,
Sir in the jury box, Your Honor.
come up, Mr. Contreras.
Your Honor, if he has a DVR for a skip, but he moves within an hour of that time limit, and he's also been to 3 AAs. He has approved documentation, five AA meetings since the last time he appeared in court.
I don't know why you're laughing. I don't know why you're happy. This is your third damn bond violation, Mr. Contreras.
He's not a state judge.
You're going to jail today. I don't know what else to do. You're obviously not getting it. But if I let him go, what happens?
I'm going away.
Stop. No. It's a third bond violation, Mr. Contreras. The bond is set at $100 now.
Understood, Your Honor.
Okay, what do you think?
5,000, Your Honor. Your Honor, and he has 4 children and works as a plumber, which I can afford 5,000.
I'll do 3501. Who's your number 2?
Fontana. He's actually here in the audience.
Okay, how's it going with Mr. Fontenot?
He's great. He made 22 job applications.
Great, and you've been able to verify that?
I'm sorry?
You've been able to verify that?
Yes, I have. He also has the numbers of the managers if you want to reach out.
No. I trust you. I want to know
He
that
has an interview
there's,
today at 3 p.m.
great.
And we also sorted out a PTI to resolve this case.
Okay, so we'll set you off a couple of weeks.
I'm going to be out of town the next 2 weeks anyway, so
Okay.
I'll sort that out.
Third,
for you.
sure.
Thank you.
Okay. Hey, when he comes back, you better have that job. Just let him know.
Thank you.
Okay.
I'll let you see.
Yes, ma'am.
Morning, Your Honor.
Hey, what's up?
Yes, Your Honor. First one is Compare. Amy Compare.
Okay,
And we got an answer. She's from PCI.
okay. Is she here now?
You require that.
Yes, so we'll send it for a TRAS. Today's Thursday, is that okay? Okay, we'll send it for a TRAS now. We'll set you up a couple weeks so you guys finish everything up.
Sounds good. Your Honor.
Yeah? Okay.
Thank you so much.
Have fun.
Have a great day.
You too?
Yeah, my first quick one.
Sure.
On this Compare, they're asking me to come back on the 7th, on the trial on the 7th in Galveston County.
Well, you don't know that for sure.
I'm not sure. The person said,
You want to do it the day before?
I was gonna ask him to come back on the 11th. I got a PSI hearing on the 6th. Here,
Fine.
is it okay on the 11th? Thank you. Hey, can we wait for her appearance? Is that possible?
No, if it's not done, she needs to be here. I get it, but if she doesn't have the interlock, or she hasn't paid the DA fee, by then you're gonna be like 220 days old, she's gotta be here. If she's got everything done, then she doesn't have to be here.
My concern is how long it's gonna take for me to get the contract.
Usually it's pretty, hey guys, on Compare It, can you make sure that they get the contract now, please?
Yes, sir, that can be.
Yeah, we can do that.
If by next week you haven't gotten the contract, let me know and I'll get them to do it. But
Sounds great.
I don't want to come back here in 220 days, nothing's been done, and then oh man, I need another 3 weeks. No,
Well, you know me better.
well, I know, but it happens to everybody. Something happens, you got to go out of town, you got this, that. So that's why we make it required unless everything is done.
Yes, sir.
If everything's done and then they're ready to file the supervision order, at that point, she don't need to be here because
Sounds good.
there's no need.
You're missing the contract. I just want to make sure I send the right.
He just got approved. We can just look at it on Compare.
Yeah.
So he wants us to call back on the 11th. I told him my concern is just how long it's gonna take to get the contract. I don't want the contract to drop.
My experience is they usually get it to you guys
Just
pretty
have
quick.
everything done by the 11th.
Did you appoint someone to Gatherton? Who got it?
The sooner we get the contract, more likely I can get everything.
I will send you the.
I think
Thank you so much, Sean.
Yeah.
Thank you.
All right, take care.
Hey,
Hey, what's up?
Just I'm here, Louis Martinez.
Yes,
You know, I'm going to give you some good news.
what's that?
I got the contract right here,
Great.
and he's got the $300 check, soon we're out of here, we're going up to the floor. And then this should, we'll have it then Saturday at 1 o'clock, and he's done with it.
Do you have the appointment already? Do you have the appointment already?
Yes, sure.
Okay, I was gonna give him, no, but I'm putting on the scram for now until he's in,
Right.
but, okay.
I just
Yeah,
want maybe 10 days.
yeah, you got it, no problem, but I want him to, he's gonna get a scram now because of all the violations,
And
so.
then soon, we'll be in the program next week, because I'm going, you have to do
The
seven.
quicker you in it, the quicker we're done with everything.
Because you have to get up and back and move there in order to get training. I guess.
Yeah.
Okay. Thanks.
Yeah, okay.
You don't have to say that.
I mean, you said what, a week, 10 days? What did you tell him? Sure, whatever you need, doesn't matter. My only concern is one thing. I only have one concern. That's my only concern. Sure. Okay.
That was generated.
She's basically reporting to the probation officer after she gives her therapy. I don't see any something with the results because I'm doing this and maybe it's just the. She wants to.
What's the cost number?
25. 35. 43.
Ms. Treadwell, come up. Shh. Around this way. Come up. Up here. Behind the bar. I'm bringing you here as a last resort. I don't want to have to put you in jail, but at some point, we cannot continue the way we are going. You have conditions that you're supposed to follow, and I understand that there are issues. We all have issues, but you're still expected to remain in compliance. So aside from IOP and SOP, has she done anything else?
She's completed her victim impact analysis.
Okay.
In the DWI education course.
Wonderful. So the only thing she has left is IOP, SOP?
And reports of probation. She gets off in September.
When do you think, you're enrolled in IOP right now, correct?
Yes, sir. The estimated discharge date is May 4th, 2026.
And then SOP will be,
After that,
how long will SOP be?
November.
I'll make you a deal. If you get done now, no hiccups, no issues, no positives, no problems with the probation officer, as soon as you're done with your SOP, we'll take you off. IOP is intensive outpatient treatment. Once you complete that, you do supportive outpatient treatment. It's supposed to be followed up with first, the one is intense, and then they kind of gear it down little by little by little, and then try to wean you off to get you to go on your own with the tools that they've given you to successfully navigate just everyday life. That's why we do this, so that you kind of get an idea of how to go forward, how to be able to cope and deal with everything, even when you have severe stressors in your life. I don't want to keep you long. I don't want to keep you on any longer than necessary. And so if you can complete this both straight through without any issues, we'll take you off. We've had significant issues up to point, and I don't want to have to file a motion to revoke your probation, because the way it stands now, your bonds are high as is. If I have to file a motion, it's going to go even. You understand?
Yes, I just put the That's what he does, the rest of his well. And I'll talk to you about your thoughts and stuff.
Everything will be done through, I'm assuming, West.
27 cases at just 33 years old. That's not a bad streak. That's a lifestyle. In legal terms, this is exactly the kind of history that destroys your credibility in court. At this point, the judge isn't asking if you'll reoffend. They're asking when.
Folks, you just have to show up, participate, and don't use. That's it. All right? All right, man. Good luck. Okay. Does she have any fees?
Let me go. So you want to since we don't.
Yeah, you can go. We can go.
Yeah.
If she has any fees, just kill her.
Thank you.
Oh, hey,
Hey, this is my approach.
please.
I'm just,
Just the last name of your client.
Morales, M-O-R.
Okay?
What I was gonna say is, Judge, this client, is not here today. And so, well,
Yeah, it is what it is, man. Okay. Do you want to stay on it or do you want to withdraw?
probably withdraw. Do you need me to follow motion or?
Yeah, yeah.
I'll follow motion.
We should have him in the tower there and then, yeah.
Sounds good. Thank you.
Okay, for sure. 5,001, please. Hey, I'm about to go to court 10. I'm going to court 10. Do you need anything?
Can't do it. We as soon as they swear injured.
Okay.
When we approach.
No, do it and then we'll get it done and then I'll go.
My son taught me this. Okay. You ready for the thing?
Yeah. Come up, ma'am. Up behind the bar. Is it a second that's reduced to a first? Let's see. Ms. Franklin,
First.
yeah, she has a prior one that was dismissed in 21. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you a probation for 13 months, but it is 1 year in Harris County Jail. We will probate that for 13 months. You will now have a conviction for driving while intoxicated on your record. What that means is that from now on, you will be facing a minimum of 90 days in jail for any new ones. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand? Is this what you want to do? How do you plead to the offense, guilty or not guilty? I'm going to find you guilty, sentence you to the 1 year in Harris County Jail. However, I'll probate that for 13 months. You will have to do an effective decision-making class. You will have to do a repeat offender DWI education class, 1 victim impact panel. You must also do a TRAS to see what are the conditions you need. If they assess other conditions, you must fulfill them. No drugs, alcohol, testing. You must maintain a guardian interlock. You are, while you're on probation, not to refuse any breath testing. Meaning, if you're pulled over in the next 13 months and an officer asks you to submit a breath test, you must do it. If you fail to do it, you're in violation of this agreement. If you violate this probation, I will issue a warrant for your arrest. I'm going to put you in jail, bring you out. We will have a hearing to determine if you violated this agreement. If you do, you are looking at a year in jail. Do you understand? Also, lastly, a $100 one-time donation to Mothers Against Drunk Driving. Does she have a license?
She does, Judge. It's not eligible.
You are not allowed to drive. You will need a portable device that you're going to take with you. You will also sign an affidavit promising us that you're not going to drive, ma'am. I'm telling you now, the worst possible thing you can do in this life for the next 13 months is either drive or consume or pick up a new case. That is an instant warrant. Do you understand, man? If you drove here, you may not drive home. Your license is not valid. All right, good luck. Please see the clerk.
Thank you, Judge.
Thanks.
Robert,
Hi.
Robinson,
Okay. Robinson, come up.
Page 23.
Thanks. I want you to understand something, and I want you to hear me loud, and I want you to hear me clear, Mr. Robinson. The Texas Constitution does not allow me, but in extremely limited circumstances, to hold someone at no bond. You are now in that situation. You are charged with violation of a protective order. If I place conditions on you, you violate these conditions, I can have a hearing to hold you at zero bond. Zero bond. And I will do it in a heartbeat to protect every person in my community. Do you understand? This is now your third violation of a protective order. You violate these conditions. It's just,
You know, when we're saying the third violation, is that from the last two that were dismissed?
correct.
So this is a refile of those two. Like, it was initially came in as, there's only one allegation.
Okay. What happened, if anything, if you don't mind?
It is complainant, do you want me to just read the PC?
Who's the complaining witness?
A volunteer at a church.
Yes, Judge.
Okay. You are not allowed to go back to this church. You're not allowed to have any contact with the complaining witness in this case, and you're not to be in possession of any weapons. Do you understand? Mr. Robinson, I'm not asking much from you, man. All in one, don't pick up any new cases, don't have contact with this person, and don't have a weapon. If you do, I'm just gonna go bananas on your bond. Don't. It's just, I'm not asking much from you. Don't pick up any new cases and don't have contact with this person. Anything you want to talk about now? Sure.
Just that, right now is not the time to contest the allegations.
Yeah, Mr. Robinson, you have plenty of time. You can go to trial, you can do this, you can do that. I just don't want you to pick up any new cases and putting the conditions on your bond that I think will, and hope, will prevent you from picking up any new cases. Stay away from this person, stay away from the church, and don't have any weapons. All right, we're gonna have conditions created for you to sign. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Sebastian. If he tells me he cannot get a hold of you because you're not responding to him, I will issue a warrant for your arrest. If I have to revoke your bond, I'm telling you now, it's going to not go well. All right, thanks.
Judge states bond.
Yeah, state's conditions, yeah. Mr. White?
Hey, Judge.
Hey, come on.
I'm not here to talk about Mr. Ronnie.
Nice.
How about that? Nice.
Just the last name of your client.
It's a client that I have on docket for tomorrow.
Okay,
His name's Richard Blanco. It's a DWI and a UCW. Sean looked at it, emailed me an offer. The reason I'm here today is because I've got to be in Brazoria tomorrow for a felony.
okay.
So I just wanted to see if I can preemptively talk to the court, have Mr. Blanco come in tomorrow, and then I was going to have Mr. Holtzman appear on Zoom, if that's okay.
Sure.
And that way he can,
It's a first setting?
it's a first setting.
Yeah, yeah, of course.
And so.
You can zoom in too,
I know, I just don't, I'm gonna be down there doing a felony plea, so I don't know how available I'll be.
whatever you want.
Okay, I mean, is there anything that we need to do now while I'm here?
No.
I'll waive PC.
Oh, yeah, actually, why don't you give a date to Victoria so she knows what you want?
Okay.
That way, we'll just reset it and we'll,
And that way he can just be here.
just be here with do conditions and then go.
Perfect.
Yeah.
Okay.
Have you done an attorney record yet?
Yes.
Okay, great.
Okay, all right, thanks,
Okay,
Judge.
sure.
Yes.
Hi, are you ready? Come on up.
My client is in the, it's for a lady, Mr. Flores.
Okay, they're getting him? Okay, he's coming.
Thanks.
Yes, ma'am. Yes, ma'am.
Is it a true first?
Yes, sir.
Do you need the cause number?
I gave it already.
I already have it.
Yeah, we can't compare to that.
Quick legal breakdown. This is the probable cause stage. The judge isn't deciding guilt yet, just whether there's enough evidence to move forward. And honestly, with surveillance footage involved, this is not looking good.
We'll do them. We can do them both at the same time.
Right, but it's really damaged.
Hey, on Ross, you're going to dismiss the second case. I guess you're going to dismiss the, is Mr. Ross your client?
Yeah.
They're going to dismiss the AFM.
Yes.
On the VPO, it is a family member, right?
The, girlfriend, yes.
Yes. Okay, because I'm going to do an affirmative finding. Okay, Mr. Flores, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 3 days in jail with credit for the 34 days you have done. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this forever. You can never change your mind or undo this. Is this what you want to do?
Yes.
Likewise with you, Mr. Ross. How do you plead to this offense, guilty or not guilty, Mr. Flores? I'm going to find you guilty. I'm going to suspend your license for 90 days. You need to understand that this is an enhanceable offense. That means this is going on your record. If you pick up any further DWIs, it is a minimum of 30 days in jail. Good luck to you, sir.
Thank you, Your Honor.
Thanks, Mr. Fernandez. And Mr. Ross, come on up. Sir, you're charged with a violation of a protective order. You're also charged with assault of a family member. The agreement that you have worked out is they're going to dismiss the assault case in exchange for your plea on the violation of a protective order. Understand that a successive violation of a protective order within a year, you're looking at a third-degree felony. This also carries an affirmative finding of family violence, meaning that you can never own a gun or ammunition as a result of this plea bargain agreement as well. Do you understand? You are giving up the right to a trial, the right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. As part of the plea bargain agreement, they're dismissing the assault you're pleading to the VPO. It is 105 days in jail with credit for the 35 days that you have done. Is this how you understand it?
Yes, sir.
Is this what you want to do?
Yes, sir. No.
How do you plead to the offense, sir?
Yes.
I'm going to find you guilty. I'm going to follow the agreement, sentence you to it. Like I said, there's an affirmative finding of family violence. Don't pick up any new cases. Do you understand? All right, good luck to you, sir. Thank you, Carl.
And we got.
You too. Take care. Hi, Sean.
Good morning, huh?
You ready?
Yeah, how are you doing?
Doing great. How are you?
Okay, that's right.
I come up. I don't know how much you know about this gentleman.
Oh, I'm sorry.
I don't know how much you know about this gentleman, but he is 33 years old. This now is his 27th case. He is on bond and has 2 open cases in Fort Bend County for the same thing within 1 year. It is a 4th criminal mischief. Deputy, I'm finding your bond wholly insufficient. I don't think that there's any non-financial conditions that will protect our community and that you will abide by. You have repeatedly shown that you are incapable of, look at me, self-control. Mr. Gatterson, of all the cases over the last couple years, one thing is evident and one thing only. Self-control has a... I want you to look at me so we are on the same page. Self-control is a killer. And there are many people in TDC now doing life because of the lack of self-control. 27 cases, and you're 33 years old. That's nearly one case for every damn year you have been alive. At some point, we got to say when, but it's just not fair to everyone else. You understand? We do what we do for a reason, not out of hate, not out of spite. But I don't know what we need to do to get a hold of you so that you understand that something catastrophic at some point is going to happen, and you will have dug yourself such a deep hole, your butt's never going to crawl out. It's unacceptable. No, I know that you're going to tell me it's rainbows and gumdrops. Stop. Mr. Gatterson, paper tells me everything because actions speak louder than words. And 29 in 33 years of life. No more.
If I may, just
sure.
In my client's case, Your Honor, the majority of those cases were dismissed, Your Honor. So I understand that there were arrests, but a lot of them did not lead to final convictions. Over half of them, probably 70% of them were dismissed, Your Honor. So I would ask the court to take that into consideration as well. Keep in mind, Your Honor, he does have these. There are cases in Fort Meade County. There's still a presumption of innocence, Your Honor. I do understand that he had a history with the same types of crimes, but a lot of those cases were dismissed, Your Honor. So we're asking the court to take that into consideration before making a final decision on this. And so my client has indicated that, he was also was in the process of seeking treatment, mental health treatment, to try to help deal with his anxiety and issues. So I think that my client understands.
I don't think so. I don't believe it. I don't think so. And I think that your bond is wholly insufficient. You have 2 open cases, and the time for you to do what you said that was way long ago. It's too late now. Sorry. I just don't think that it's a good idea with all those open cases, and that it's a 4th mischief within a year. It's not a good idea. I don't think there are any conditions that we can place that will.
So what is the position, Charlie? Are you setting a bond?
Of course.
Okay.
You tell me what you want. I mean, I'll be reasonable, but I just don't think another PR about this. At some point, the revolving door has to stop, and it stops now. It's not fair to everybody else in this life. No. I'm okay with whatever you want within reason. What do you think?
Well, $500.
No. It's going to be a couple thousand at least, but.
Do 1,000.
Do 2,000.
We'll do 1,500. That'd be great.
Sure.
Okay.
But it's not a revolving door. He will have a GPS monitor upon release with a strict curfew of 7 to 7. No contact with anyone, no dope, no alcohol, no weapons, and we'll see how it goes forward. But I need him to understand The door closes. It's not going to keep opening and keep.
From my understanding, he does have a monitoring, on current report being.
And he picked up a new case. Right.
So you're going to require now 2 monitors. I'm just,
Because we can't attach to that monitor, right? I don't know. I can't attach to that monitor, so I have no idea what'll happen.
Think about how quickly this escalates. What starts as a personal dispute turns into a criminal case with property damage and potential violence. One bad decision in the moment, and now you're facing the full weight of the system. Was it worth it?
So, yeah, okay, thanks.
so 1,500.
1,500 bones.
All right.
Thanks.
Thank you.
Okay. Hi, please, just the last name of your client. Okay, where are we at?
Okay.
Oh, okay. I thought I saw that. Okay, Mr. Del Rio, come up. Mr. Del Rio, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you a 1-year deferred. Deferred is a type of probation that if you complete successfully, there's no conviction on your record, but you need to understand you give up nearly every right known to man entering into this agreement. If you violate said terms and agreement, you're looking at an entire year in jail. Do you understand? That means you must comply with all the classes, all the conditions, no testing positive, no weapons, no new cases. Yours is going to be tough because you have to do something what's called BIP. Batters Intervention Prevention Program. This is a class that you do once a week for 18 weeks. You can't skip. It's a curriculum that's set up for you to go once a week for 18 weeks. If you skip, they're going to kick you out and then we issue warrants. Do you understand?
Yes, sir.
You must also do a 4-hour anger management class. You must do a TRAS. It's an evaluation to see what other conditions you need. If they assess other conditions, you must fulfill them. No drugs, no alcohol, 10 hours of community service. Does the complaining witness want contact here?
She does, Judge. That's why we did it as no threatening, harassing.
She's okay with it?
Yes, Judge.
So there's no threatening or harassing or abusive contact with Miss Pina. Do you understand these conditions? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, right to be arraigned, charged, read in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you either complete it successfully or it gets revoked. Like I said, if you do something to violate this agreement, we issue a warrant, we will put you in jail, bring you out, we will have a hearing to determine if you violated this agreement. If you do, you're looking at a year in jail. Do you understand? Anything else that you guys you have concerns about? There's one more thing, Mr. Del Rio, and one of the most important things. There's an affirmative finding of family violence. What that means is that if you ever pick up one of these cases, another one, you will be looking at a 3rd-degree felony, 2 to 10 in the penitentiary. Do you understand? You can never own a gun or ammunition as a result of the plea bargain agreement as well. All right? How do you plead to the offense, guilty or not guilty? I'm not going to find you guilty. I will withhold that for 1 year. The biggest thing with this, Mr. Del Rio, is that you do stuff on time. You will be given certain times to do things, when to get it done. The probation doesn't work on your time. It works on their time. So you have to know when everything needs to get done. If you fail to complete that things on time, a warrant issues. All right? All right. Good luck to you, sir.
Thank you.
Thanks.
Yeah, excuse.
Yes, sir. Thanks.
Robinson Terrence.
Okay. Hi. Hi.
B-A-R-R.
Okay. Bond or jail?
Bond. He's here on Monday at Fort Lee, stated PR bond.
Okay.
He was released Tuesday afternoon because he needs a longer on. Then yesterday was a report to pretrial because there's an issue with the bonder. They fixed now. There's a whole lot of him back here today.
We'll give you a reset. Yeah. As long as he's in compliance and everything, yeah.
I believe police and bring up drug house to emails.
Did we send him?
Or if you show up, they have.
Yeah, send him and then we'll deal with it tomorrow then. I mean, if you got here super late, that's on, yeah.
We have a solution for that.
Okay,
I'm going to speak with the non-social workers about arranging transport, so that way he can get here.
okay, sure. Not a problem.
All right.
Yes, ma'am. Thanks. Hi.
Good morning.
Good morning.
I'm approached from David. Last notice the case that I came in Friday, going to be bottom out. Must have been, it's an all out, it's cause number is 259-5721.
259-5721.
Yeah.
Okay. Lasco, come up.
Go around.
Yes.
Thanks. What is this? Well, no, I don't need that. That goes to the state. No, those, yeah, I mean, you keep that, I don't need that. I need a PSR is what I need. Mr. Lasco, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On April 11th, 2025, officer following up on a report from the complaining witness where an alleged tracker was placed in her vehicle and whereabouts were being tracked. Complaining witness stated that she and the defendant, her husband, had just left the Astros Stadium when they got into a verbal altercation. Complaining witness stated that he was intoxicated, that the defendant was intoxicated and began to drive her and her son home. Defendant was enraged, leaned in as if to kiss her, but bit the side of her lip, causing pain. Complainant stated the defendant took her phone immediately and refused to let her call for help. Defendant then proceeded to bash her head against the dashboard as her lip began to bleed. At the hospital,
He hit her head, smashed her head in the
dashboard. As at the hospital, the complaining witness did not want to press charges, but later stated that she said that she did that because the defendant threatened her children.
Mr. Lasco, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, that will revoke your bond, put you in jail. I'm now issuing what's called a magistrate's order for emergency protection. This is a court order that identifies.
It was a mistake. The report was made on April 11th. The allegation happened in December of, it was April of last year. And the report was made in December of this year, maybe 8 months later. Just some background information. In addition to that, this complaint was made 8 months later, right when they get into the divorce. And she puts the children and stuff inside of this report. I talked to my client since she said this allegation was false. She ended up writing that affidavit last month or January, 2 months, trying to get this case removed because the things in that case weren't true.
Are they going through a divorce now?
Yes, they were already separate. So
Great.
They've been communicating. This happened a year ago. So this.
I'm still going to issue the protective order just in case, because there's a protective order and because there's a divorce going on and I don't want any more bad blood between them.
Indeed, I want you to know because they see each other every weekend for picks up and the drop off. She wrote the affidavit, said like it says in that paperwork. He threatened her. She doesn't see him as a threat to her. So I don't know.
I don't know that. I don't know what she thinks. I'm not going to assume anything.
No, she said it right there in the affidavit. Sworn by her.
I'd like you to reach out. Before I allow contact, I want to hear it from her. I don't know who did that affidavit.
Understood.
How do I know that she did that?
Well, how are we handling? Can we do something non-harassing so we can?
Not until I know from her that she wants it. No, I get it. I want to hear it from her first because I don't know who did that affidavit. I don't know if he had his next door neighbor do it at the Burger King next door. I don't know. I'm happy to honor your wishes, but I want to hear it from her first because I don't know what she says. So, I mean, it's kind of late now, but I can have Sean, and when we get the line down, reach out to her to see what her position is. But understand, Mr. Lasco, I'm entering a protective order. If you have any kind of contact with her until we modify these conditions, I will put you in jail. I'm going to protect my community at all costs. Do not consume alcohol. Do not consume illegal drugs. You will be tested. If I find that you're using, I just have one place for you. Do you understand? I'm not asking much from you. I just, at this point, don't have any contact with her. Don't use alcohol or illegal drugs. That's it. Oh, no weapons as well. You understand? The protective order states that you cannot have any threatening or harassing contact with her. You cannot Commit an act in furtherance of an offense under section 42.072. This is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. I like to honor complaining witnesses' wishes. If they seem fit to have contact, then I will allow it. But I want to hear it from them first. I don't take anybody's word for anything. In this life, you're only as good as the proof that you have. And so I don't take anyone's word as much as I like him. I'm not,
And here's the full picture. Multiple open cases, repeat offenses, and zero signs of slowing down. At this stage, the judge isn't just reacting. They're trying to protect the community. Final question. Do you think this ends with another chance or something much harsher?
I want to hear from her. Do you understand? We can wait a little bit to see if they're able to get a hold of her. If not, we can wait till tomorrow. I mean, it's, just got to understand also, there's a lot of vindictive people in this life. If you're going through divorce and this case is open, do you understand? Be very careful. All right. So can you file no contact, no weapons for now, and then later on you go out and try to contact?
Yes, Judge.
Okay. All right. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him and he'll tell you if and when you have to come back to court. Give me a bond that you want. I can't give him a PR bond, but tell me what.
1,000.
Sure. Okay.
Thank you.
Please. So bond set at 1,000. Okay. Hi.
Hi, Judge.
Hey, what's up?
Mr. McDaniel.
Give me a second. Make sure I get this.
I got no.
Okay, McDaniel. Okay, oof, that's old.
Yes, sir. We filed PTI in March. We gave him a decision. He's already done the TRAS. I just went and sat down in front of that. And she made a decision just now.
Great.
And approved it.
Okay.
So that's where we're at.
So we'll give you 2 weeks to get everything done then. It's 250 days.
I understand. It's not our fault.
So we'll give you 2 weeks and hopefully if they're done within the 2 weeks.
If we get the contract, it'll be good. We'll see.
So we reach out to Bernadette, make sure that they get him the contract today or tomorrow, please.
Yes, sir. Thank you, Judge.
Hey, Corey.
Yes, sir.
What's up, buddy?
Miss Libby on the docket. We were here last week.
Is it starting with an L or with
EL?
EL. Okay.
She's done the class, she's done the community service, she signed the contract, she came today, she didn't get a cashier's check. So I think she's trying to run to it. Right?
You want to roll till tomorrow?
Yes.
Yeah, go for it. Not a problem. Okay, counsel, coming up.
Good morning, Judge.
Hey, good morning.
I really only have one case I want to.
Just the last name.
Last name is Rogan.
Rogan? In jail?
Well, kind of is in jail in Jefferson County.
Oh, this is that case.
This is that case.
What happened?
I confirmed this morning, he's still there. But I did speak with the ADA. I'd like to ask if we can reset this for about.
I don't know, man.
Before we revoke the bond, only because the VPO they spoke with the CW. CW doesn't want it prosecuted because.
That's not my concern.
I just hate to have him going back and forth with warrants here, warrants there.
Actions have consequences. That's my concern more so. Did he pick up this case after that, before?
I can fill you in, Judge. He had a probation violation warrant because of this case. And there was another, he's got a probation bond denied case in Jefferson County right now. Don't have a court date. He's also got a new unadjudicated case. He's being held for $15,000. Spoken with his family. He posted the bond. But I'm hoping if I can get this case dismissed.
That's going to take another couple of years out there,
It could. That's what I'm hoping, Judge.
Yeah, I have to revoke it.
I understand.
Yeah. What's the cause number?
It is 260.
Okay.
6057.
Yeah. That was a new one out there. That's a new case after this one. So, I'll just raise it by $1.
Okay, I appreciate it.
I mean, it's not, I don't.
Yeah, sure. I appreciate it.
Thank you, Judge.
Okay, take care.
Now, first-
Hey, Mr. Glenn. Hey, good morning.
Mr. Graham.
Okay.
Graham, we asking for a short reset for evaluation purposes.
It's 220 days old. You guys have had since February to consider, sorry, since March. Do you have an offer in the case?
We do, Judge.
Is the defendant here?
Oh, he's not here, Judge.
So a week? Okay, he's got to be here. It's either plea or trial. Okay, he's just really old.
Okay, that'll work.
Okay,
I have one other,
okay.
Mr. Thomas, hi, Thomas.
Okay,
This one, was supposed to refile as a felony, they have been unable to do so, I think the chief.
Let me take a look, Judge.
I'm gonna set it for trial. I'm not gonna just sit here and wait anymore. It's 160 days.
That's fine, Judge. Yep. At that point.
Yeah, we would be willing to plead to the case, we express that to the state as a misdemeanor.
Yeah, I don't know why, it just, hey, get his phone. Get his phone. I think he's recording. The gentleman in the white shirt. Can you take a look, please? It looked like he was recording. When can you get it done?
I'm sending it to that right now. I'm just not my case, Judge, wasn't aware of that, and I will try and get the chief to do that today.
I don't know how long it takes for that to happen, you know? Yeah, so I'm giving you 2 weeks.
Yes, sir.
At the next setting, if it's not,
We let Bernadette is, we let her know about it too. We're the board today.
if it's not done, then by 2 weeks, really.
Yes, sir.
Okay,
All
all
right,
right,
thank you, Judge.
thanks. You ready?
Yes, sir, good morning.
What's up?
We, approaching on PC,
Okay, last name.
Luke Kuhn, Luccun.
Luke Kuhn.
Yes, sir.
Are you ready?
Yes, Judge.
Okay, go.
On April 13th, 2026, in Harris County, Texas, officer was dispatched to a family disturbance call. Officer met with complainant who has been in a relationship with defendant for 2 years. She stated he has hit her in the past, but that there were no reports. Defendant got upset at complainant for being with her brother-in-law and punched her in the face 3 times. She stated she felt pain. Complainant stated defendant also punched her son with a closed fist and threw coffee at him while she had him in her arm.
So wait, okay, so the defendant
Yes.
hits a Miss Tubak in the face 3 times.
Yes, Your Honor.
Judge,
Unless you see something I don't,
yes,
tell me.
if it pleases the court.
Yeah. Okay. She was cheating on her,
Okay.
and well, he's already talking to him. He's claiming no punching, no hitting. He does have like scratches and marks right here.
Who?
Him.
Oh,
Here. I don't know if I think it's like scratching, right? He's like, I was just trying to get the baby away from her. I wanted the baby. And it was like, nothing happened today, but she does hit me in the like previous, and she does hit me because she accuses me of cheating. So it seems to be like it's.
Oh, okay. Well, she got visual injuries, right? No, she doesn't have visual injuries?
So because of that, there's no visible injury. Someone gets punched in the face 3 times, you're gonna have something. And it's not. Yeah, I think that,
Is that the lone reason why you're saying that there's no problem, just because there's no visible injuries?
yes, Judge, we have someone getting punched in the face 3 times, we're gonna have something.
What's your response?
Well, she bodily injuries pain, and she stated she felt pain.
Judge,
I don't know. I could there conceivably, We don't know how hard he hit her. We don't know where he hit her.
In the face. She's saying in the face.
Yeah, but where in the face? In the eye, in the cheek, in the chin, on the lip, in the nose? I don't.
I understand.
It's very vague. I don't.
The state has offered a time served. I have told my client not to take it. He has an immigration hold.
That sucks. Have you spoken to the family about maybe an immigration bond?
He has prior deportation. He had immigration court and he didn't show up to court, so he has a deportation order. Judge, I don't feel good leaving this case out.
Don't. And I'm not asking you. We'll get you a short trial setting.
I told him